Take your time. We're not going to start till everybody's out of here. Yes. I'm sorry, I can't hear you.
Mr. Flint co-counseled portions of the case with me, but he's not going to be participating in the argument. Is it okay if he sits at this point?
That'll be fine.
Okay, thank you.
Questo, whenever you're ready, we'll proceed.
May it please the Court. May it please the Court. I'm Wendy LaQuasto of Fox & LaQuasto. I'm here today representing claimant Sylvia Romano. I'd like to reserve 4 minutes for rebuttal. I've raised 3 issues in my briefs. The first one has to do with the exclusion of the deposition of Dr. Walker. The second one is the denial of temporary indemnity benefits. And the third one is the denial of penalties, interest, costs, and attorney's fees. And unless you have any questions on the third issue, which is just a derivative issue, I'm going to rest on my briefs on that. On the first issue, that is, claimant alleges that the JCC erred as a matter of law and fact by excluding the deposition of Dr. Walker because he became authorized by operation of law under Section 440.13, sub 2, sub C. As you know, 440.13.2c provides that a claimant can seek treatment on his or at the expense of the employer carrier by the physician of his choice if the employer carrier refuses a request for care.
It appears to me, tell me if I'm wrong, that the ruling and what's really critical here is the language in 2C says there must be a specific request for the initial treatment. And if, finish the question and you can go on. If we do not have this request in front of us, if the JCC did not have the request in front of us, have you complied with the statute, or how do we determine whether you complied with the statute?
That is the critical issue. It's actually when that request was made. And I understand that the documents aren't in the record, but Adjuster Malowski testified, I faxed a response on 2/24/09 denying psychiatric care. So, I submit to you that when you send a response, that you are doing that in response to a request, and her testimony is evidence. And, we maintain that there's nothing in Section 440.13.2c that requires any written document at all. I cited a case law in my brief that said that you can request it in a telephone conversation. You have to look at that request in terms of not only what the literal plain language of the statute is, which omits any sort of written requirement, but you also have to look at it in terms of what 2A requires in terms of an EC's duty to provide reasonable and medically necessary care. That's once they know. There's all those cases, those old I think I cited some in my brief, attendant care cases that, once you look at a person that's really disabled after an accident, and, you can't just say, gee, I didn't know they needed attendant care. And no one requested it. It's just like, this is what your job in this employer carrier monitored system is.
What was the purpose of saying specific, though?
I'm sorry?
It doesn't just say request. The statute says specific. What was the purpose for putting the word specific in there?
I say specific as to the kind of care that you're requesting. And in this was specific in terms of it's requesting psychiatric care, per the, with Dr. Walker. And that's what they're asking for. I don't think that there's any question that it's, and I don't think there's any ruling any argument that it wasn't a specific request. I think it's the timing. It all has to go in the absence of the documents. And our position is that the JCC has misconstrued the statute by requiring an informal written grievance to be the triggering mechanism for a request under 2C, and there's nothing in 2C that requires that you actually file any written document or any formal request. By construing the document that way, the JCC was able to say, well, you made your request in May and you went to go see Dr. Walker in March, so you made your request after you already visited him, which is not what's contemplated in the rule. And that's how you get to that, that's how she got to that result. But she only got to that result by ignoring all the evidence that showed that there was a request made in February, which was denied. And that's the triggering mechanism for a claimant to be able to go out and get self-help under 2C.
Counsel, what legal authority do you have for us to construe the term specific in the statute to mean exactly what you said, that it's a type of care rendered rather than, for instance, the name of the doctor, the type of care, the duration of treatment? I mean, there are other considerations that we could certainly construe the statute to mean. What authority do you have for your definition?
Well, you're asking me a question that's outside the briefing and the issues that we brought up. So I would have to do supplemental authority with your permission to do that. I'd be happy to look for that. I don't think that my recollection of case law is that a request for psychiatric care, certainly per the recommendation of someone or with a specific doctor has always been specific enough in the past. But I'd be happy to do supplemental authority if that's what you would like. It's not an issue I'm prepared to really answer. Anything that I put forth would be outside the briefs, and they wouldn't have had a chance to respond to that.
Understood.
The JCC's reasoning that the formal grievance was the specific request. I submit that that's contrary to the plain language of 2C because there's nothing in 2C that requires that. It's also contrary, as I said earlier, to the employer carrier's duty to provide reasonable medically necessary care that they know or should know is needed. And it's also contrary to the purpose of the workers' compensation system, which is quick and efficient delivery of medical benefits to injured workers. The EC has argued, they argued below, they argue above, that claimant needed a referral from a treating doctor in order to make a specific request. And this is a defense that is raised repeatedly in workers' compensation. It's something that's, and you look at pretrial orders, you'll see it all the time. No referral for the requested care, for the care. There's nothing in 2C that requires a referral. There's nothing that says you have to get a referral from a treating doctor. Geez, if you had a referral from a treating doctor, then I don't know that you'd have to, why would you have to go to 2C to get help? It doesn't make any sense. And I think it would be really helpful for the court to clarify that that's not a legitimate reason for refusing a request for care.
We didn't clarify it sufficiently in parity?
I'm sorry?
We didn't clarify it sufficiently in parity or parody or however you pronounce it?
Parody. I don't know that the issue about a referral came up in parody. They cite parody for the authority.
They're not talking about a request at all. They just said somebody seeking authorization. Doesn't require them to actually have a referral, does it?
No. No.
That's a friendly question.
Well, I get stuck. I've been scratching my head about parody because that's what they cite for their proposition that you have to have a referral, and I don't see it in there. It's just a question of.
That's a question I'm going to ask them as well.
Yeah. Well, to me, parody just says you need to make your request before you go out there and seek it, and that's really what it says. And that's how the JCC, that's the correct interpretation. Her problem is when she reads into the statute the requirement that you have to have a formal grievance to make a specific request. So on the first issue, we ask that you reverse and remand for reconsideration of all the claims, because the JCC said in her order that this was Dr. Walker's deposition would necessarily impact indemnity benefits. So it not only will impact the claim for psych, it will impact indemnity benefits, and that includes all the penalties, interest, attorney's fees, and costs, too. The second issue that I have is error in the denial of temporary benefits, and I submit, this is kind of a derivative issue, too, in terms of, I think the Boggs versus USA Waterski says that once you ascertain that there's error in the exclusion of testimony that's essential, and here the JCC said it would necessarily impact temporary benefits, that, you need to reverse it and send it back for that. So I'm not really sure you even need to reach issue 2 other than just to say, and reconsider temporary benefits. I think that I took the time to say some things in my brief about findings and reasoning that the JCC employed in the denial of temporary benefits that I think are wrong. I think your Toscano case, which you just issued, it's going to be very helpful to everyone that does TPD claims, and I think that she could be directed to review that, because that has a very good explanation of the factors that need to be considered whenever you're going to do temporary benefits. We submit in this case that this judge just determined that because Ms. Romano lost her job because of budget cuts in the school district, that that her loss of earnings is all just because of some unrelated economic factor. But that analysis ignores all the other issues that Toscano points out are very important. This woman had restrictions by every doctor who treated her fractured foot. When you look at her undisputed testimony about what her job is, she can't stand from 7 o'clock till 4 o'clock in the afternoon on this broken foot. She, in fact, did her regular job, and her foot never healed. And that's the reason we have such an ongoing claim here. She also did a job search, and it was unsuccessful. She got one 4-day job. And all of these factors are things that the JCC needs to consider in determining whether a claimant has satisfied their burden for entitlement to temporary benefits. And so we think it would be instructive to the JCC to have some directions on that and remand.
You're down to 4 minutes.
I'm into my rebuttal, and so I'm just going to simply say on issue 2, we conclude that ask you to reverse and remand for reconsideration in light of Walker and all the factors in Toscano. Thank you.
May it please the Court, my name is Tina Ballantyne, and I'm here on behalf of the employer carrier appellees in this case. With me today is Mr. Chuck Flint. He was co-counsel for the trial and in writing the briefs, and he will not be speaking. I will be handling the whole argument as discussed earlier. I want to first address a couple of the points that Ms. LaCosta made on behalf of the appellant. First, I heard that we assert as the appellee, and that Judge Jenkins wrote in her order, that a formal grievance only could constitute a specific request. I urge the Court to look back at her order, because in fact there is nowhere in her order that she states that.
Well, she talks about, in the absence of a referral or recommendation to support the request, it would have properly been denied. And then she talks on the next page, I believe, about okay, I'm sorry. Well, maybe it's better to do it this way, because I lost where I was going to read from in the order.
Right.
Is it your position today that you need a formal referral or recommendation prior to seeking care or from the carrier?
I understand what Your Honor is asking, and I don't want to interrupt you, Judge.
No, go ahead.
Okay, thank you.
That's pretty much done.
Okay. It is my position today, and in writing the briefs and in studying what happened at the final hearing and writing the briefs, I did kind of realize after writing the answer brief that secondary argument that I had about needing a referral, I don't think, after reviewing the case law further in preparation for the oral argument, that you would need a referral because of Parati and 440.13.2c.
Okay, I appreciate the concession, and I appreciate that you did that.
Thank you, Judge.
So that kind of lets us focus on the argument here.
Right.
And the question of what constitutes a specific request. tell me in your mind what a specific request would be. I mean, what is the statute seeking to get there?
Well, I couldn't find any authority, any case law authority or any part of the statute for 4013-2C that specified what a specific request or that defined what a specific request could be. So I think under the legislative intent, or looking at what the legislature intended in amending it to include a specific request rather than just a request, I think it's fair to say that the legislature intends for the JCC to make that determination on a factual basis.
Okay, I understand that, but it helped me. They need to make a factual determination, but in order to make a factual determination, what was that language trying to get at? Putting the language specific in there, and then I'll ask a follow-up question after you answer.
Yes, sir. I think what they were trying to get at, I think we see so many times in workers' compensation that the claimant requests a certain type of treatment. They're unhappy with the treatment that's provided. I don't think that is directed at Ms. LaQuasto or at this particular claimant. But in general, I think the legislature and the court saw a trend where the claimant would start treating with a certain provider, not be happy with the treatment provided, and would request another treater. And if they had already used their one-time change in physicians, they would have a problem or a disconnect and an argument on the claimant's behalf saying that we didn't really request that physician a year ago. Now I'm making my actual request for treatment with whether it be an orthopedist or a psychiatrist. So I think the legislature intended for the claimant to have to take it a step further. It's not enough to simply request it. You need to be clear and make a specific request so that you can't later on come to the court and say that you never made a request beforehand.
Okay, I'm not sure I disagree with you. It seems to me that the intent of that language has to be, we want this to be specific enough and to give the carrier enough time so they really understand that a claim for specific treatment is being made. Would you agree with that?
I do, Judge.
Okay, so, the carrier can't get hoodwinked.
Right.
It appears that that would be the intent of this language. Now, here, by the adjuster's testimony, notwithstanding the fact that the request wasn't in there, the denial wasn't in there, her testimony seems to indicate that we got a request and we denied it, which would seem to indicate to me that they knew enough to understand they were getting a request for another treating physician.
Right.
So if, in fact, if I'm reading that testimony right, what more did we need to find out about the request?
Well, I think the situation is that in her testimony, and this is also what Judge Jenkins pointed out, was that there was a confusion between the testimony of Dr. Halperin, the testimony of Ms. Mulaski regarding the treatment requested from Dr. Halperin, the objection they had to Dr. Halperin's treatment, and the date of the fax letter and response. I think, personally, if the JCC had had the letter and response before her, there is a good chance that we wouldn't be here. Or at least that she wouldn't be the appellant, that I would be the appellant. Because I think then the judge could have determined whether or not.
You're arguing to me that the evidence could have been better. I agree with you.
Right.
This was probably tried abysmally. That they should have known where the letter was. I mean, I don't understand how somebody goes to trial where one of the key issues is a denial, and you don't have a copy of the denial there. Having said that, I'm still trying to find out where the evidence is lacking. Obviously, the evidence could have been better. But if the if the carrier knew a request was being made and they had enough information to deny that request, what further information would they have needed to have the statute complied with?
Well, one of the things they would have liked to look into is which authorized provider, because before 440.13 comes into play, I think the claimant still has the burden to prove that the care she's requesting is reasonable and medically necessary. Now, if the carrier just sort of sits on its laurels for a certain number of months or a year and doesn't ever investigate that or talk to that authorized treating physician to further investigate, I don't think 440.13 2C takes away the employer carrier's right to investigate whether the treatment should be provided. I think we still have that right.
Yeah, and clearly that's what the statute seems to indicate, that, you'll have a reasonable time period to respond.
I think that's the reason. Go ahead.
Here, they weren't, from the testimony of the adjuster, it doesn't appear that they were saying, I need more time to respond. I deny your right for authorization for a new physician. That concerns me because If the testimony was, well, we were still looking into it, we were still looking about whether it was medically necessary, but it seems like they denied it. So how can you say, well, we need to do more investigation?
Well, also in her testimony earlier on, before the very last sentence, I believe that you're speaking of, Your Honor, where she says she denied it and said if a referral had been provided, she would have authorized it. I think the point there is that if there had been a referral attached, and there may have been, we just don't know, it wasn't made part of the record, but if there had been a referral attached, or if we could have looked at the letter and the JCC could have looked at the letter and determined that, okay, it's specific enough, there is a referral attached, or it's specific enough because she states clearly what kind of treatment she wants, and she states which physician, because for all we know, the letter could have stated which physician referred her, and the JCC didn't have that at her.
But going back to the referral, is there any necessity for a referral?
I think in the beginning, when you're investigating a claim, there's a necessity for a referral, and otherwise the employer carrier wouldn't simply grant any type of treatment that the claimant wants. I think as part of the claimant's burden, it would be to at least give a basis for why the care is needed. I don't think it's enough, in other words, for the claimant to say that they need psychiatric treatment, especially in the claimant's deposition, where she said she desired psychiatric treatment because her attorney told her that she would need to go see Dr. Walker. I think it's a different set of facts.
What if she'd submitted a letter saying, I think I need psychiatric care? Merely said, I think I want to treat with Dr. Walker and I need psychiatric care. Would that be sufficient?
I think that we're getting closer, if that was the case. If she genuinely thought she was depressed, this is a young lady that came to the deposition and was really unclear why she was treating with Dr. Walker. She simply went there because her attorney told her to. So I think those are the kind of details that if Judge Jenkins had that at her hands to look at and to review, factually, I think she could have probably reached a different conclusion.
Could the carrier have denied the request simply because it wasn't specific enough? So as Judge Wolf says, if they request, I need psychiatric care, not as opposed to, I need psychiatric care because I'm depressed or because I can't sleep. I mean, do you think those factors need to be in there for the carrier to assess the claim?
I think I don't know that it does. I don't know that most claimants are able to articulate or know to articulate what's going on from a legal standpoint. In other words, I think they know if they're depressed or if they're anxious, but they might not know to put that into the letter. I think that if the claimant herself had said, I know I need psychiatric treatment, then I think we're getting closer to a specific request. But to say that my attorney told me to go see Dr. Walker and the first visit with Dr. Walker took place 1 month from the time that she hired her attorney, to me that just shows an intention on the claimant's part and opposing counsel's part to send her to Dr. Walker. They were determined that that's who she was going to treat with, and it's outside of their right to select the treating physician.
Didn't the adjuster basically say here that they denied psychiatric care, so they knew there was a request for care, they knew it was for psychiatric? Doesn't that put some obligation on the carrier to either give the care or put them at risk if the claimant can determine that it's medically, or show that it's medically necessary in the future?
I think, and it again goes back to Judge Jenkins and the fact that there is CSE, in my opinion, to support her argument, to support her findings, that the claimant didn't meet her burden to show a proper claim was filed or a proper claim was made. Now, had the letter been available and Judge Jenkins, in her discretion, could have looked at the letter.
Can we back up a second? Would you agree with me that this pretty much, it's agreed that there was a claim made for psychiatric treatment, and it was denied? I do. I look at it and I take that away from her testimony. I make that inference based on her response, that she responded that psychiatric treatment was denied. But unfortunately, I'm not the JCC, and that's kind of where I wanted to. I guess I got a concern here, and I understand that you're saying that evidence could have been more specific. But when you have the adjuster, who's the representative of the employer carrier, who admits that there was a claim for psychiatric care and it was denied, it almost seems like that's a stipulation to me, that really isn't an issue. And I see where you're coming from, and I think that is an inference that could be made from the evidence that was made part of the record. But I also see how the other inference can be made
from Ms. Malaski's deposition testimony and the questions being asked of her by opposing counsel.
What if JCC Jenkins had said, I determined that no request for psychiatric care was ever made? Would we be here and she saying there is no competent substantial evidence to support that? And what would your response be?
Let's see. I think that without some great case in my favor, I think I would have a hard time. I think that if Judge Jenkins had said absolutely no request was made, I think that she would have ignored that part of the justice's testimony that said that there was some type of request. It seemed to be that the part that the JCC didn't feel she had enough of evidence from the claimant, and the claimant hadn't met her burden on, was to actually attach the document to the record so that she could view it and herself make a determination whether or not it constituted a specific.
Is that a legal mistake if she said she needed the specific document rather than testimony to support it?
I don't think it is. I think it is I think she would have a hard time as a JCC, and I understand why, of determining whether something is a specific request if you can't look at it and tell or hear if it was a recorded. Go ahead.
Sorry for interrupting, because it seems to me you're asking us to hold as a matter of law that a request has to be in writing, otherwise it cannot be a specific request.
That's actually not so, Judge. Also in this case we had a different issue where there was a verbal request for a one-time change, so I don't think that requests have to be written. I think that if it had been something where someone could have come to court and testified and told Judge Jenkins what the request was, we don't even have testimony from anybody, from the claimant, from opposing counsel, from someone opposing counsel's office that they could have brought in as a witness to say, what did the specific request say? There's no verbal indication as to what the specific request said either. So I don't think it has to be written. I think it just has to rise to the level of Judge Jenkins having the ability to view or hear what the specific request was so that she can make a determination whether or not it was specific enough.
Okay. Let's go back. And because I know I got your answer from this before, but I don't remember it.
Sure.
If we can look at this and say she, or the claimant here, requested psychiatric care, and that was it. I need psychiatric care. What more was required?
Well, I don't think anything more is required. I think where we are differing on this issue is that Judge Jenkins never heard that testimony from the claimant. She never heard that. All she has a response.
When she heard it from the adjuster.
Well, all the adjuster said was, I denied psychiatric treatment, and said if a referral was provided, that she would provide treatment. And I think one of the inferences that can be made was that the request said, I need psychiatric treatment, but we don't know what the request said. It could have been a request from her attorney saying, please provide psychiatric treatment to my client with Dr. Walker, or please provide psychiatric treatment because she's depressed. In other words, if Judge Jenkins had that to make that factual determination of whether or not the request was specific, as the legislature requires, then we could, we'd have it attached to the record, and I think we would be looking at a different appellant and appellee in this case.
Okay, but I keep on going back, and I'm not sure you directly answered this. What specificity would you need in there that is more than I need psychiatric care?
I think that the legislature, by not defining it, leaves it up to the JCC to decide what is specific. And I think it's within her discretion to decide what is specific. If she looks at it and feels that it's, a specific request.
Somebody can go in front of Judge Harnage in Miami and do this, make the exact same request as this person in front of Judge Jenkins, and they have the discretion to say, well, in Miami it's different than in front of Judge Jenkins.
I would argue yes, because the judges that we practice in front of all have different standards of what, for example, some of them will not require to have an attachment to a petition for benefits of a referral from a physician. They will find that the petition is specific enough without a referral attached to it. That's happened to me in front of Judge Hofstad in our area. But if I take that same petition and I do a motion to dismiss in front of Judge Murphy or Judge Jenkins, that usually will be denied because there's not a referral attached. So I know there are situations where...
if we have the exact same facts come to this court, I mean, we usually don't get it this way, but we have the exact same facts in these two particular cases. There's no dispute as to the facts. Doesn't it become a question of law as to whether something was specific enough if we have a stipulation of facts? And wouldn't we reverse one of them if they had the exact same facts in front of them? And one said it was sufficient, and one said it wasn't sufficient. Wouldn't we be required, as a matter of law, to make a determination that one was right and one was wrong?
I think so, and I hope in that situation that you'd be able to view the actual request or hear what the actual request was rather than hearing what the response to the request was, so that you could determine whether it was specific enough. And I think I see where it's a matter of law as to whether or not something is specific enough, but the employer carrier's point is that from a CSE standpoint, factually, we can't look at what the request was. We just don't have that
I
information.
understand that. Give me a little bit more time. Thank you.
Oh, okay, thank you, Judge.
Okay. You have exactly 15 seconds to conclude.
Oh, I do. It says 2 minutes, and that must be wrong. Well, Your Honor, in that
You've run 2
case...
minutes over.
Oh, okay, I'm sorry. Thank you. Well, I'd like to go ahead and take this opportunity to ask respectfully that this Court affirm Judge Jenkins' opinion as we believe it is supported by CSE and it is a factual determination. Thank you.
I don't guess it'll do me any good to say that specificity wasn't an issue below, because it's obviously an issue here. But no one defended this against this on the basis that the request made in February wasn't specific enough. I refer you to pages 211 and 2 through, I think, like 215 in the record, which is Malowski's testimony, and that's where she talks about her authorization procedures. And she says, I only have, notes on it, but my notes indicate that she says that they get a referral, they review it, then they determine if they need additional authorization to provide the requested benefit. Here they reviewed the request for Dr. Walker and decided not to authorize it. So I think that in her testimony, it's pretty clear that she knew that they knew claimant was asking for psychiatric care with Dr. Walker, and I think that makes it specific enough. I think to the extent that you look at specificity 2, you have to read that in paramaterial with 2A, which has the duty of the employer carrier to provide reasonable and necessary care, and that it is an employer-monitored system, and that they have an obligation to investigate what needs to be provided. So maybe that's the reason specific isn't more defined. I will say, too, that it was at this point that, and we don't have the letter, but I will say that it was written by her attorney. In fact, that's the time that Ms. Romano actually got an attorney. She represented herself through most of this and contacted the adjuster, and it was at this point that she got the attorney.
I know you weren't the attorney below, but it wasn't a very good attorney.
Well, I wonder about...
I shouldn't have said that. I'm sorry.
I wonder about, things don't get attached, and I'm not sure... we can all look at it in hindsight to see how it is. I do know sometimes I get depositions from in my record that don't have attachments on them, and that's a court reporter problem. I don't know that this is a court reporter problem in it, and sure, it would have been nice if it was there. But I do think that, as I said in the beginning, when I first got up here in rebuttal, that this was not an issue below. No one's saying this wasn't a specific request. And to the extent of their defense was there wasn't any referral. And they've conceded that they didn't need to have a referral to be able to authorize this psychiatric care. And all they needed to do to avoid all this was offer alternative care. Some alternative psychiatrist when it was offered, and then they could have done a 120-day pain investigate. So we ask you to, unless you have more questions, reverse and remand with directions to reconsider all the claims in light of Dr. Walker's deposition and opinions. Thank you.
Thank you for the excellent oral arguments. No further cases in front of the court. The court will stand.